from the Supreme Court in Abuja, which has now ruled that the trial of Nnamdi Kanu, the proscribed leader or the leader of the proscribed indigenous people of Biafra, must continue. It was a cross appeal, so to speak, between the federal government. Nnamdi Kanu himself also filed an appeal on the matter. Our correspondent Celestina Iria is live for us now to bring us some more updates on this breaking news. Celestina, we understand that the Supreme Court also slammed the federal government in the way it brought in Nnamdi Kanu for his trial in Nigeria. Tell us more about the verdict of the Supreme Court today.
Well, what this means is the fact that irrespective of the conduct of the security agencies, what Nnamdi Kanu ought to have done was to come by way of civil procedure, which is filing a fundamental rights enforcement suit before the court challenging the conduct of the security agencies. The court agreed with him that yes, he ought not to be having extraordinary renditions to Nigeria, and this was in violation of the Kenya Extradition Act and the Nigerian Extradition Act, but that cannot stop the proceedings from going on. The court, however, said that the lower courts, being the appellate court, which is the Court of Appeal, and the trial court, the Federal High Court, were riding on sentiments, and the court shouldn't be doing that. It has to be based its actions according to law, and so far as Nigeria is concerned, there is no law stopping a trial or an accused person from being tried in an offense whereby the security agencies maybe violated his or her right in the process of arresting him or bringing him before the court.
Do we have any reactions from Nnamdi Kanu's legal team now with this development? Yes,
they spoke to us. They were not very happy because they had expected that the courts will also align itself with uphold the judgments delivered by the Court of Appeal, but that was not the case because of the fact that Nnamdi Kanu has been in detention for over 2 years. So they are saying that it is more like a step backward for them because right now they have to go back to the Federal High Court and the trial has to continue from where Justice Binta Yanku had initially adjourned indefinitely, waiting for all these proceedings to go to the Court of Appeal and the Supreme Court. So for them, yes, they have to go back and answer and make their client, which is Nnamdi Kanu, come before Justice Binta to answer the pending charges. The court, however, said that they sympathize with him, or they are not in agreement for the fact that his house was invaded in 2015, which brought about the reason he fled the country. So the court said that they would not blame him for fleeing the country, but the law must take its course. Nnamdi Kanu has to go back to the Federal High Court to answer to the remaining 7-count charges. Initially, it was 4 counts. The federal government amended the charges. It became a fresh 14-count charge in which Justice Binta Yanku struck out 8 counts, leaving 7 counts. It was that 7 count that found its way to the Court of Appeal, where the Court of Appeal said that for the fact that illegality was committed by the security agencies, they cannot try Mr. Kanu. The court said you cannot put something on nothing and expect it to stand. So the court asked that Nnamdi Kanu be released immediately. That was as at that time. But the federal government, having come in to appeal that decision, prayed for the court to stay execution, which the court did. So Nnamdi Kanu came to the Supreme Court, challenged that stay of execution that stopped his release, and the federal government came to the Supreme Court also to challenge the decision of the Court of Appeal. So this was the issues that brought about the appeal before the Supreme Court, and now the Supreme Court has given its verdict. Nnamdi Kanu has to return to the Federal High Court for its trial.
Right, Celestina Iria, TVC News Judiciary Correspondent there. Thanks a lot for these updates.